So we proceed to count number 9, child pornography, contrary to section 16(1)(b, as read with section 16(1)(g) of the Sexual Offences Act, number 3 of 2006. This one I'm going to read the particulars. The particulars in this count are that on the 2nd of October 2023 at an unknown place, the accused person intentionally and unlawfully exposed a minor, GS, aged 17 years, to obscene images, audio, visual, by sending a link whose detail the court has concealed to avert further dissemination to the minor using the social media network that is outlined in the particulars herein. The court has considered the ripple effect of sharing the dark web pornographic link with a minor, which the court reads as aggravating factor due to the risk of further dissemination within the community and globally, and hereby sentences the accused person, Jan Intelveld, to 5 years imprisonment. Under count number 10, child abuse, contrary to section 22(1), as read with section 22(2) of the Children's Act, number 29 of 2022. The particulars under this count are that on diverse dates between the 16th of January 2022 and 26th of May 2022 at a known place, the accused person intentionally and unlawfully through a social media platform, namely WhatsApp, and for the mobile numbers provided, received obscene images of the minors AA, aged 10 years, and AB, aged 7 years, for purposes of sexual gratification. Under count 10, the court notes that the victim are sisters, aged 7 and 10 years, whose nude photos out there are likely to negatively impact their future chances into dignified teenagehood and adulthood. The internet, as earlier said, never forgets. In the view of this court, therefore, the 73-year-old accused person deserves a custodial sentence under this count for the ripple effect of generating the pornographic material of the 10 and 7-year-olds. The court notes that the accused person showed no remorse and justified the same as private family time that should not have been exposed to the main media. The accused person is hereby sentenced to 3 years imprisonment under count number 10. So I will proceed because they are further issued, and the further orders are to the effect that to conclude on the sentencing, it may be important to point out that prosecution did not produce any evidence of previous conviction, hence the lower threshold of the fines being imposed by the court, pursuant to section 14 of the CPC, expounding on the sentence to impose in cases of conviction of several offenses at one trial. The section provides that when a person is convicted at one time, is convicted at one trial of 2 or more distinct offenses, the court may sentence him for those offenses to the several punishments prescribed, therefore, which the court is competent to impose, and those punishments, when consisting of imprisonment, shall commence the one after the expiration of the other in the order the court directs, and unless the court directs that the punishments shall run concurrently. To this end, the court orders as follows. Number 1, that despite the advanced age of the accused person, the minors herein considered him their father, but it betrayed their trust. The custodial sentences imposed in count 1, 3, 9, and 10 shall therefore run concurrently. The sentence will take effect from the 24th of November 2023, which is the date the accused person was apprehended. Number 2, that the court hereby makes a victim restitution order under Section 26 of the Victim Protection Act as follows: that in addition to the fines outlined above, the accused person shall pay a restitution amount of 1 million to each of the 3 victims herein, that is AA, who is PW1, AB, who is PW2, and GS, who is PW3 in this matter. The court further orders that the restitution shall take precedence over the fine. Number 3, that all the phonographic materials in relation to the 3 minors herein shall be expunged from the social media points, visual media platforms with immediate effect. To this effect, the Director of Criminal Investigations Child Protection Unit shall ensure compliance with this order through the collaboration of the relevant authorities that are engaged in this field. Number 5, that the exhibits containing the phonographic material shall be forfeited to the Communications Authority within 14 days from the date of this judgment for purposes of destruction. Number 6, that upon completing the sentence, the court recommends that the CS Immigration orders the removal of the accused person from the Kenyan jurisdiction pursuant to Section 26A of the Penal Code in accordance with Section 43 of the Kenya Citizen and Immigration Act. The right of appeal is accorded to the accused person within the next 14 days. The accused person is at liberty to appeal against this judgment.
She must be very happy. Oh, sorry. And members of the press, I am innocent. And if you want to know, you can listen to me.
1 hour ago,